Good morning, thank you for joining us today for Webinar Wednesday for April 2016. Today we are looking at the Construction Design and Management Regulations 2015, known as CDM Regulations, and we're looking at them 1 year on from when they were updated and implemented last year. So we're really looking to see how they've affected you in the workplace. My name's Katie and I'm looking after you today as the moderator for this webinar. So if there's any questions or problems that may arise throughout the duration of this, I'll hopefully help you out. To get in touch with us today, you can use the question box, which is in the admin panel on the right-hand side of your screen. You may need to expand that into your screen. So just send us any questions that you may have throughout the course of this webinar. And again, as I've just said, if you've got any feedback on how the regulations are affecting you in your working environment, in your role, we'd really like to hear from you so we can perhaps incorporate some of that into the session as well. So again, just feel free to type straight in. What we'll do is we'll pick up as many as we can as we go along. If not, we'll address them at the end. If we do find there's quite a lot of questions on the same theme, we'll potentially look to compile some frequently asked questions that we'll publish available online as well. If you're on Twitter, we have hashtag CABE, CPD as usual, and you can get in touch with us that way as well. And so today, your speaker looking after you is Kevin Blunden, Deputy Chief Executive for Technical Issues here at CABE, and he's the man in the know and he'll be able to talk you through it. So without further ado, I'll hand over to Kevin for this morning's webinar.
Good morning. So this morning we're going to be looking at the CDM regulations. They've been with us now for a year. Although obviously originally we had a sort of a transitional period whilst they settled in. So what I want to look at today is some of the issues that are coming to light as a result of having to try and deal with those regulations, and some of the legal guidance that's been given to the courts and enforcing bodies about how it actually should be dealt with once it gets to that stage, and also some practical information that's coming out of some of the professional bodies on maybe some of the interpretation matters that sit alongside the basic regulations themselves. And as Katie says, what we're trying to do is build a picture of how this is really working in reality, what difference it's made, and particularly the implications on maybe the smaller designer, the small to medium business, who perhaps had peripheral dealings with this before and have more to do now. And in addition, those perhaps in the domestic market who are having to give a lot more guidance and support to their clients. The main drivers for the legislation in the first place were obviously to achieve better health and safety. And one of the reasons that the CDM regulations in 2015 looked to deal with domestic projects far more than perhaps it had addressed in the past was that actually an awful lot of the health and safety occurrences, particularly injuries rather than occupational health, occur on the small domestic construction sites. So the approach with the legislation was hopefully to try and simplify things, to reduce the bureaucracy and the amount of paperwork that had to follow and flow around the process, but to focus on the actual risks, and then to adopt a proportionate approach rather than in every instance something that might be a little bit more draconian. So the simplification part of that process was to look at the projects, look at the notification, and look at the duties that apply to individuals. So some of the notification of projects that required the F10 form to be completed and submitted to the Health and Safety Executive have changed significantly, so that the scope of projects that need notification has changed. It may now include some domestic projects where previously it didn't, but at the same time some smaller commercial projects may not need notification. But one of the key factors was to emphasize on the duties and responsibilities of all of those involved in the process, and to make sure that those duties applied regardless of whether a project needed notification to the Health and Safety Executive. So everybody involved in the process has a duty in respect of health and safety, and those have now been somewhat clarified, but in the domestic sector still very heavily leading on the client and the people advising them directly. So the changes have presented a number of challenges for the industry in terms of how we try and move some of this forward, not least of which is actually trying to disseminate this information and make particularly the client groups aware of their responsibilities, and then in the domestic sector to ensure that contractors and designers understand their role within the process. But some of the other challenges that sit there are around sharing of information, communication, and trying to, as far as possible, understand risk but deal with this matter of what is proportional. So we cannot in some instances totally eliminate the risk. We have to take proportional measures to try and deal with what's reasonable within the circumstances in terms of what's a foreseeable risk. So it has to be reasonably straightforward. And then we have to look at how competent is the workforce to deliver some of this. Now in terms of designers, then obviously there's a degree of competence and understanding in the work that they do, and those who are members of professional bodies generally will sign up to a code of conduct where they agree not to do work outside their own level of competence. But some of the framework that used to be within the code of practice to the CDM regulations that dealt with how we could assess competency for dealing with these regulations was removed, as was the code of practice when these regulations changed. And that has led to some gaps in interpretation and a need for the industry to produce guidance to try and fill some of that void. So in terms of what's happening legally, there is a great deal of information out there, but there is still confusion about people's individual roles within the situation and how the legislation applies and what actually means in practice. So there is quite a large education process ongoing to try and make sure that people understand, but it's reaching the audience that needs to know, the small contractor, the client groups, the individual who's having a project carried out, and getting that information across to them in a manner that's easy to understand. And then the industry has to adjust to these requirements, and particularly in terms of designers, it may be that where they're looking to become or be appointed as the principal designer, there's an adjustment perhaps in the philosophy and the thinking and their role. So we've had the introduction of the legislation, we've dealt with the transition period. To be honest, until we get to the infringement prosecution side, it will be difficult to actually drive some of the education process. If you look at a lot of the industry news that comes out in the headlines more or less on a weekly basis about prosecutions under health and safety legislation, particularly in the construction sector, you'll see that currently we are seeing headline cases go through the courts and fines in result of prosecutions to work that was actually carried out and things that went wrong probably 18 months to 2 years ago. So it is going to take a while for some of those headline cases under the current regulations to start making the headlines, which will drive the education and information process when people realize what the possible ramifications of not following an appropriate approach may well be. What has happened recently, though, is in relation to all health and safety offences, new guidelines have been issued by the Sentencing Council to the courts, and these relate to health and safety offences, corporate manslaughter, and very much the approach that's being taken when they're looking at the level of fine or conviction is actually based upon what the issue was. If there is it's almost a risk assessed basis in relation to convictions, if you like. It's looking at what could have gone wrong, how serious could that have been, and how likely was it to have gone wrong. And then to a certain extent there's also how big is the organisation, should they have known better, and was this a deliberate and flagrant breach of legislation, deliberate cutting corners, or realistically was this a one-off when somebody didn't necessarily realise there was an issue. Now, not realising there was an issue, not understanding the legislation, being a small organisation, none of those are excuses for not complying with the legislation, but they are all taken into consideration when the level of penalty is being considered. So I mentioned that notification has changed, and again, one of the issues that's perhaps causing or has caused a little bit of confusion is how do you work out when you need to actually notify the health and safety executive in terms of a project or not. And the key principle here in terms of notification has to be that the notification has to be sent, and it's an online process, but it has to be completed as soon as it becomes apparent that the project will trip the limits in the notification process. Now that may well be in the project planning stage, in negotiations between the designer and the client early on, or it may well be later on once the job's actually underway and things start to overrun and it becomes obvious that the project is going to take maybe longer or need more resource than was originally thought. So the notification is basically, if the project is going to last more than 30 days, and at any time during that 30 days there are more than 20 people on site, then it needs notification. Now one of the things that needs clarifying there is that is 20 people on site at any stage during the process. It doesn't mean there have to be 20 people continually on site for all of those 30 days. So once you get to that element, then the project is notifiable, or if the project in total is over 500 person days. So it may be that there's significantly less than 20 people on site, but the project is going to take quite a long while to complete. And this could well be a domestic project that is going to rattle on for several months with only a few people on site. And at that point the project needs notification. So the F10 form has to be submitted. Now the onus for who actually has to do that may well fall back to the client, and they may well then look for their professional advisors to assist them in doing these things. So in terms of where the legislation applies, the legislation applies to all construction projects. It deals with all projects including domestic. The coordination duties of sharing information and ensuring that parties are doing their relevant roles kick in where we're likely to have 2 or more contractors on site. And in basic terms, we have a principal designer looking at the pre-construction phase and a principal contractor who coordinates the construction phase. Unfortunately, it's not always as simple as that to actually define when one phase starts and when one begins. So just one comment that's come through, can I just clarify the less than 20 people again? Yes, just to make it absolutely clear. If your project lasts less than 30 days and there are less than 20 people on site, then that does not require formal notification to the health and safety executive. But what it does still mean is that the regulations still apply and the responsibilities still apply on that site. If at any time during that 30 days there are more, during the construction period there are more than 20 people on site, then it requires notification. If the project in total is more than 500 person days, it needs notification. Obviously, if you had a project lasting for more than 30 days with 20 people on site, you'd have hit 600 people days anyway. So we're looking at longer than 30 days with more than 20 people on site at some time during that process, and it requires notification. Okay. Looking at the scope of the regulations in terms of where we are, we have in essence under CDM now 2 different types of client. We've got the commercial client who's having a project carried out for them, and the domestic client who is dealing with the work. It's not part of a business. As far as the legislation is concerned, all clients have duties. In the domestic sector, it may well be that they have more duties, but that some of them fall to other parties within the process, such as the contractor. So what's actually being discussed and debated at the moment? A great many of you may have come across situations where you're designing a project, because the legislation applies, you've been asked if you would consider being the principal designer. And we are hearing that a lot of clients are assuming or insisting that designers become the principal designer. Now the principal designer basically has a role when we've got more than one designer in place. They're then looking at coordination and information, but it also filters into once we've got the contractor and sharing the information going forward from there. The principle behind the legislation of the designer's role and the principal designer was to actually put the responsibility with someone who is fully integrated into the design process. And it would be fair to say that in these changes to regulations a year ago, the biggest change was in relation to the design side. The principal contractor role didn't chiefly change, except perhaps in some domestic projects. But in terms of design, what we did was we removed the CDM coordinator and we put a lot of those responsibilities onto the principal designer. And the reason for that, as I say, was that there was a feeling from the Government Department and Health and Safety Executive that actually the CDM coordinator could sometimes stand one step removed from the design team. And to embed health and safety into the process, it needed to be somebody who was fully integrated into that. So the legislation, it gives an indication that the principal designer should be a designer. And perhaps where there's some debate in the industry at the moment is whether that principal designer has actually to be doing some design work in relation to the project that we're dealing with, or do they just have to have a design background? Now again, the issue is that they should be in a position to influence the health and safety in the process. So the implication of the legislation is that there's somebody who's integral into the process, but again there is a debate in the industry at the moment as whether they have to be a designer on this process or whether they can be a separate appointment by the client. Now that obviously would open the way to those individuals who had previously been CDM coordinators still being principal designers, albeit not actually dealing with design on this particular project. But what is important about the principal designer role is that they must have the right skills, knowledge and experience to be competent to carry out the role. And again, one of the things that was removed was the code of practice, and that set down as to whether somebody is competent or not, and the principal designer in taking on that role will have to be sure that they are competent to do so. Right, let's have a look and see. I've got a couple of questions popped in, so let's have a look and see what's likely to be happening there. Somebody says they are currently taking on some projects where they resolve planning and building regulation issues where perhaps the client has ceased to use the original designer for one reason or another, or they couldn't satisfactorily resolve things. Does that make them a designer under CDM regulations? Well, in essence, yes, if you're giving advice on that relates to the design, albeit in relation to planning and building regulation applications, you are still a designer, and therefore you may be looking at liability. There's also the issue, obviously, if the original designer who was dealing with it, who's now stepped away, was also doing the principal designer role, the client will have to look at whether they're looking for you to carry on that role or not. In essence, if you're taking over the role of a previous designer, yes, you're considered to be a designer in the legislation. Right, somebody's just advised me they've recently been to an HSE presentation and it was specifically confirmed that 2 contractors on site includes subcontractors. That is quite right. In terms of the terminology, when we're talking about more than 2 contractors on site, it does include subcontractors, so they count as a contractor. There'll be one then principal contractor coordinating and looking at the issues relating to any other contractors. So when it says more than 1 contractor on site, it's not more than 1 main contractor, it does deal with subcontractors as well. Anyone's preparing a specification or schedule of works is regarded as a designer. Yes, that is the case. They are. Anybody who inputs into the design in any way, and that can even be to a certain extent, the contractor, if they are substituting materials or methodologies, they are doing an element of design with that. And obviously there's a great deal of overlap between some subcontractors who may also be sub-designers, if you like. So particularly if you're getting in a mechanical and electrical subcontractor to do elements of the work and they design their parts of installation, they become designers as well. Does the principal designer have to be a named individual, or can it be a company or a practice? Principal designers can be companies, practices, partnerships. It doesn't have to be an individual. They are then taking on the corporate responsibility and have to demonstrate, if you like, the corporate competence to do that role. Somebody here works for a local authority and commissions consultants to carry out works on their behalf. Do they become the principal designer, or do I retain that duty? In that issue, you are basically acting as the client. They would become the principal designer if you appoint them into that role. If you don't, then it depends on who's involved in the process as to whether there's need there. But if you are then also doing design and specification as part of that commissioning, it may well be that you could be the principal designer as well. And yes, right, questions coming in thick and fast now. Assuming demolition projects fall within this criteria, yes, demolition projects do. They do fall within the definition of construction work, and therefore they fall within this criteria. So again, if they meet those notification criteria, then it needs notification as a project to the health and safety executive. If you've got a designer being appointed for the pre-construction phase and a separate designer for the build, does the initial designer retain the principal designer duty? If the initial designer is principal designer, then yes, they would do, if they are still engaged in the project. Obviously, if they have done no further involvement and influence over the project, then at that stage the principal designer role would move over to the new designer. Right. Okay, that's dealt with a quick raft of questions. Let's see if I can move on to some of the other bits and pieces, and I'll pop back to the questions in a moment. Right. Let me get the screen moving again. There we go. In terms of the client's role, the domestic client has a great deal of responsibility, most of which by default falls to the principal contractor. However, if there is a principal designer appointed, they can take on some of the responsibilities as part of that role. When you get to the non-domestic client, it may well be that they will then be seeking to appoint the principal designer, principal contractor for every single project. So what's actually happening out there at the moment? A very cautious approach to the new regulations, with some reluctance to change and some slow adjustment. I think there is an issue that people have got used to having a separate party involved in the process in terms of the CDM coordinator, and therefore it's taking a bit longer to adjust than perhaps the transitional approach in the legislation would have allowed for. There is still the issue that domestic contractors are still largely unaware of the situation, as are the clients. There's little changes, say, for non-domestic contractors in terms of how these regulations pan out, and there does seem to be some hesitation among professionals in terms of accepting the principal designer role and the obligations that maybe go with it. And that's because some of the wording in the legislation does imply that the principal designer is taking on a role in terms of any design carried out by any other designer, in terms of trying to ensure that as far as possible that design is safe in terms of health and safety as well. So there is some reluctance there to take it on, although a lot of design practices are saying, well, this is part of what we can do, we can offer it as part of a service, and then obviously there has to be a conversation about the cost of doing that. Right, let's see where else. Next slide. Okay. Sorry, just a little bit delaying, time delay moving the slides over here. So, what are we looking at? What's actually going on at the moment in the industry? There's additional publicity going out there. There is a lot of industry guidance being produced from design bodies for principal designers, from the health and safety executive, and from industry, particularly guidance aimed to hit the hard to reach people in this process, the small builders, the client groups. And then as case law starts to build, it will give an understanding of where things are moving and what's likely to progress as we go forward. At the moment, there is a definite need for clients to be getting help from somewhere. Now, arguments would say the reality, a lot of this help came from the CDM coordinator previously. Somebody has to be providing the client with this help and assistance. Their normal port of call, the first person they're going to deal with will be normally their designer, who will then have to at least give them information so that they understand their responsibilities and that they can carry out their role effectively. Now, it is a bit chicken and egg, because as first point of contact, you'll say to the client, did you realise you need to do X, Y, or Z? And one of those issues will be to check the competence of the designer. So you're more or less saying to your client, actually, can you check whether I'm competent to do this or not? There is a lot of guidance out there, and what I would suggest is, if you are dealing with clients at that first contact, if you go onto the Health and Safety Executive website or onto the Construction Industry Training Board website, there are a number of useful little guidance leaflets and booklets there in electronic format that you can give to a client at that first meeting and say, great, you're appointing me to do the design of your project. Here's a little bit so that you understand what else you've got to do within this process. And to a certain extent, as a designer in the process, you are discharging one of your duties in terms of health and safety, because you are highlighting and educating to the client what their responsibilities in the process are. So that's one way of trying to deal with it, and I would suggest that's something that perhaps needs to be done. There are issues about how clients manage the project anyway, but designers are used to talking to clients at the beginning of the job to explain how the construction process works, how contractual arrangements work, how we work the way through the project anyway. And then maybe the only other strange thing that the clients might not have been dealing with is things like completing an F10 form if they actually have to. Okay. So the issue of competence does crop up. The client has to assure themselves that somebody is competent, and the question is, what makes up competence? In the former code of practice, there was quite an extensive list of what people needed to know and understand in order to be able to demonstrate that they were competent, and as a result, it could take quite a bit of paperwork at the appointment stage to justify that. The key about competence is that it's a blend of skills and experience and knowledge, but it has to be proportional to the job. If you're only dealing with a small project, are you competent enough to deal with that project? And do you not then step beyond those bounds? It is very difficult for the client. There isn't a great deal of evidence to help them. As I say, most professionals within this criteria have a code of conduct that says you only do work where you're competent to do so, but maybe also because the competence issue is there in relation to the contractor side, the client needs some other reassurance. And then obviously when the contractor's dealing with things and dealing with subcontractors, there tends to be in the industry quite a high reliance on things like the basic CSCS card, which at its core is about competence within the process. Okay. Anyway, now the slide's going to move. Right. So one of the other problems we tend to see with the setup in the legislation is it takes a very simplistic view of the construction process. It has the principal designer responsible for everything in the pre-construction phase, and then the principal contractor responsible once the work gets to site. But obviously that isn't how construction projects really work. We get pre-construction phase with the design, but there's an overlap with the construction phase, and then during construction, we tend to get additional designs from other designers, revisions to the design from the original designer, changes and tweaks to the design from the contractor, and then a little bit more design all the way through the process. So there is this need for communication and coordination all the way through, and there is a blurred line of responsibility during that construction phase when design is still going on. And it then relates really in terms of responsibilities as to what element of the work are we talking about. Are we talking about, is it buildable? Are we building it on site and part of the contractor's planning regime? Or is it part of the fundamental change in terms of the design? And there may well be some joint responsibilities there as we go forward through the project. So in reality, what we should be seeing is the appointment of the principal designer, principal contractor. They get pre-construction information from the client, usually with a degree of questioning and investigation to feed into that. There's then a risk management process of the design in terms of, is it buildable, is it going to be maintainable as a building in use, and will it be safe in that process? The contractor can then do their construction phase plan about how they're actually going to put this thing together and manage the health and safety on site. And then at the end of the day, all of the information that's gone into the safe building that has to be transmitted to the client so that they can own, operate and manage this building effectively has to go into a health and safety file. And again, it's one of the duties that the principal designer will have to coordinate the information that goes into that health and safety file. Okay, just picking up on another couple of questions here. Right, from a building control viewpoint, if a self-build client asks for advice on a project and follows that advice, do we inadvertently become a designer? This is a critical issue, and it's something that we've tried to cover before in guidance we've issued as a professional body. Building control, in carrying out the statutory role in relation to enforcement of building regulations, are exempted under this legislation from being designers within the process. However, as anybody does on a construction site, you still have a degree of responsibility in terms of health and safety. The issue comes with advice. If the advice itself is on interpretation of the regulations or to aid in a client's understanding of what might be in a guidance document such as an approved document, then that potentially is still advice. If the building control give a range of options of ways of achieving compliance, which might be you could do this, you could do that, you could do something else, or you could go and talk to one of the design consultants. That potentially is still advice. It's more difficult if building control starts saying you should do this. If that is the only way it can be done and it's following a recognised form of guidance, that might still fall within the exemption under CDM regs. But if there are other alternatives, then potentially in saying this is what should be done, that's building control becoming a designer. And I think that the best example I can give of this is if you've got a very constricted site and somebody has gone in, used an excavator with a narrow bucket to dig some deep trench foundations, 450 millimeters wide, down say 1.5 meters. And they've worked within the confines of the site and now got that machine to the front of the site, but they can't get it back on the site until the foundations are cast and they can get back across maybe. If building control go on the site at that point and say, those foundations aren't deep enough, they're on field ground, that's fine, and that's as far as building control should go. If building control said, somebody needs to get down there and dig it out a bit deeper, that becomes design, that has a liability to it. So there is a fine line there to juggle with. Okay, so I'm more or less getting to the end of this webinar this morning. There is just one other cat I want to put amongst the pigeons, which is obviously that CDM regulations are driven to a large extent by directives from Europe. next month should, or sorry, the month after next, should the vote go to exit, how will that leave us in terms of these regulations? Well, obviously some of the driving force might be disappearing, but ultimately we still have a UK health and safety issue to consider. The CDM regulations are UK legislation. They may have been influenced by European directives, but at the end of the day they remain UK legislation, so should we decide to leave Europe, they will remain in force unless the government would take the view to put something else in their place. So it's not really a deciding factor on whether we should or shouldn't stay within Europe. It has the same sort of degree of influence as maybe everything else we have in terms of legislation at the moment. Right, I'm going to try and pick up on some of the questions that have just popped in. If a premises is changing from domestic property to a shop, and the client changed contractor and commenced without knowledge of the principal designer, what design responsibility has the principal designer got? Realistically, the designer has the responsibility in terms of their design and the health and safety. The note on this question does say this was under the previous 2007 regulations, so theoretically there would have been a CDM coordinator responsibility there, and the designer's responsibility wouldn't have been that of a principal designer. It would have just been the normal responsibility on a designer in terms of the safety of their design. If something subsequently went wrong with the work on site that caused an injury, then that is the contractor's responsibility. If it came about because of lack of information being passed from the designer to the contractor, then that is potentially a coordination issue, and that would be being dealt with under the former regime, where there should ideally have been a CDM coordinator appointed. Somebody's saying it's not building control's role to advise on CDM, so building control may need to be very careful what they say on site. Yes, there is an element of building control aren't dealing with CDM, don't enforce CDM. They can obviously highlight it as an issue if they feel there are issues to the client, but it does come down an awful lot of the time in terms of building regulations and building control of not going beyond the remit of the building regs, and wherever possible using the phrases like this should be done, or sorry, this could be done, or you could consider doing this, rather than this should be done. And again, wherever possible, where there are other professionals involved in the process, referring everything back to the actual designers and the contractors involved in the process. Right, I'm just trying to see if there are any questions that I haven't yet really mopped up and dealt with as part of the process, and I think in general that's picked up most of them. Have you picked up on anything else, Katie? Are you still there?
Hello, yes, I'm here. No, I think to be fair, you've covered off everything that's come through. I'll just say to people that you've got literally a couple more minutes. If you've got any questions or comments that you want Kevin to address, then now's the time to type them and ping them over to us.
Yeah, fine. In which case, I think, yes, what I would say is, as an association, we are working with the Health and Safety Executive and the Construction Industry Council Health and Safety Committee to try and make sure that enough of a message and information gets out to the industry. And what I am seeking at the moment is feedback from people on the ground about how these regulations are really working in practice. So if you do have any comments to make, if you have had any experiences, if you have any particular, if you like, site-specific questions that we can't perhaps share in this open forum, then please feel free to email me at the association, and I will take your comments on board and try and get back to you with some reasonable responses if you have a particular issue. If you do need to get hold of me, my email address is kevin.blunden@cbld.com, but any of our general email addresses will get through to me as well. Okay, in which case at that stage I think I will just double check and see where we are.
Just one more popped in at the bottom, Kevin, if you can have a quick look at that.
Yes, yeah. This is another bugbear within the industry at the moment. The health and safety executive do impose charges where they have to intervene on a site where there's been a transgression. And I've just been advised by one of our audience today that their current recovery rate is £124 per hour against the guilty party. This does put fear into the heart of contractors particularly, and it is quite a controversial issue, but it's one of the ways in which the Health and Safety Executive are trying to maintain the ability to actually enforce the regulations with limited resources. That 124 hours pound per hour is something they will levy and charge for minor transgressions. When things get to the courts and the courts start looking at costs and the like, things can get much more expensive than that. But this is their base level, if you like, for dealing with minor transgressions on site, and they do end up charging back in the process. Again, there's quite a lot of debate in the industry about whether that's reasonable, as they have a sort of statutory role in terms of enforcement, but also what's reasonable in terms of cost. And actually, if you start looking at the investigation cost, the time of actually doing it, the back of house support, £124 an hour is quite readily achieved, to be honest, and could be argued isn't particularly unreasonable. Okay, I'm going to hand back now to Katie just to wrap up, but otherwise thank you very much.
Great, thank you, Kevin. Thank you for your time. And thank you, everybody, for joining us. The double act that is Kevin and myself, we will be online again on the 18th of May, where Kevin will be looking at domestic ventilation. And then following that, on the 22nd of June, we're also online looking at the limitations of the building regulations. So if there's anything there that interests you, feel free to sign up at cbld.com/webinars. Today's webinar has been recorded. It will be available on our YouTube channel, hopefully from around about lunchtime today. So if there's anything that you wish to catch up on, again, you can watch it then. And also feel free to share it amongst colleagues, even if anybody views it sort of not live, in effect, via YouTube, you can still get your 1 hour CPD. And for those of you who have attended today, you'll get an email shortly saying that you have attended and that it does count to go against your CPD records. Okay, so again, thank you for joining us. We hope you found the session useful this morning, and we will see you online again soon. Thank you, bye-bye.